This works. All right, we'll call to order the zoning board meeting for January 22nd, 2026. Heidi, you want to call the roll, please?
Here.
Leslie McKnight here. John Ball. Here. Karen Katina. Here. Christine Brochus.
Here.
Keith Kyle.
Here.
David Trentfeld.
Here.
Mr. Vice Chair, you have the floor.
All right. The first matter tonight, unfortunately for everyone sitting here, is we have to have an election of officers. So are there any nominations for chairman?
I nominate Keith. I second.
All in favor?
Aye.
That's too easy. I don't know if that was good or bad. Any nominations for a vice chair?
Nominate Ellen.
Second that. All in favor or opposed?
Aye.
Aye.
Aye, that passes. And one more nomination for secretary. I would nominate Christine.
Second.
Second.
All in favor?
Aye.
Aye. Okay, that was easy. We have a bunch of continuances, I think, tonight, so maybe if we'll take a little bit out of order to address those so that people who are here can leave. So with respect to the first matter, under administrative matters, Pelosi, is there anyone here? I believe that's going to be continued.
Mr. Chairman, sorry. At the December meeting, it was continued to the January 19th zoning board meeting, and that was by mistake. It should have been the January 22nd zoning board meeting. So this is just an announcement that the Pelosi public hearing is continued to the February 19th, 2026 meeting with notice going out again.
All right, and our council or the applicants appraised of that?
Yes.
Okay. All right. We also have to address the 2025 annual report. Has anyone had a chance to review that or have any comments on that?
I reviewed it.
I don't think there's,
I had no comments, and so I moved to approve it.
all right,
Second.
all in favor?
And it was seconded by, thank you.
Christine. Next item on the agenda is the approval of the minutes for November 20th, 25, and December 18th, 2025. My understanding is you want to move that to the next calendar so that, because they're not complete yet, right? Okay. Oh, do we need a motion for that, Nick? All right. Do you want a motion for that? All right. All right, is there a motion to? Okay. All right.
I'll make a motion.
Sec- All in favor?
Aye.
All right. I'm going to just go forward to the ones that I think are being continued, and we can get them. So the C3 is Tevereau Glance, our counsel here.
Mr. Chairman, we do not, we object to a continuance. We think that this is a very simple issue that you can decide tonight. There's two matters before you. One is a motion to dismiss that we ask that you move forward with tonight. I think that can be handled in a very short time. The substance of the matter, if you deny the motion to dismiss, we have agreed to a continuance, and there's scheduling issues that we have to talk about, but we do not agree to a continuance on the motion to dismiss.
Okay, thanks.
Good evening, Mr. Chair and members of the board. One thing I think I can agree with is I've never had a simple issue with Kelly and Bill with their standards. So I have to disagree or agree that this is not a simple issue. There are two issues before the board. One is the issue, and potentially a procedural issue as to whether or not the matter before you is even appealable. Oh, I'm sorry. I'm sorry, yeah, good call. Good evening, I'll start over. Good evening, members of the board. For the record, John Mancini on behalf of the appellants, Joshua Tevereau and Richard Glantz. Mr. Tevereau and Mr. Glantz are the proponents of the appeal which has been filed before the board. And there are two issues in front of the board. One is the actual appeal, which was filed back on December 5th, which was scheduled to be heard tonight. And then a second issue which has arisen is the question as to whether or not the appeal which has been filed is even an appealable issue. And I'm asking for a continuance on both. I understood that there was a potential for a continuance with regards to the merits because of availability of the party or one of the parties. The second issue is the question of appealability, and that would be a procedural issue as to whether you proceed to the merits. And I'm asking for a continuance on that for two reasons. One is my client wasn't available this evening, didn't expect to be here because of the potential for the continuance of the merits. But more importantly, we received a multitude of pleadings on Tuesday, and I want to be able to respond to those pleadings, and I also want to be certain that the board has responded to those pleadings because the issues are important, and I think they are a bit complicated and not as simple as just decide whether we should or should not be here. So with that, I respectfully request the continuance, and I think that they should both be heard simultaneously at the same night, if you will.
Mr. Chairman, just to respond to that, Mr. Mancini has known of, sorry, Kelly Morris Salvatore. Mr. Mancini has known about the motion to dismiss and our arguments about dismissal since January 2nd. He responded on January 3rd with his arguments. We filed a formal motion to dismiss earlier this week, but we were hoping that staff would not accept the appeal administratively because there's no decision. There's no additional argument here. I think that you're going to find when you take, and Mr. Tevereau being unavailable is irrelevant. It's a procedural issue. There doesn't need to be any testimony about, from Mr. Tevereau at least, about whether it's a decision or not. But in terms of efficiency as well, I want you to consider the fact that if this dismissal is allowed, then we're done. If it's not allowed, then the next time we come, we have to be prepared for both the dismissal argument plus the substantive argument, which this is what we've got in front of us. So I think it's more efficient for you to hear the simple issue of whether this is a decision or not, and I'm going to ask Mr. Pimentel to weigh in on that because he's the one that authored this document. And then we can move on if there needs to be some substance. But you have everything in front of you, and Mr. Mancini has everything in front of him since early January on this. Thank you.
So I don't see the, go ahead, Mr. Mancini, before we,
Look, I'm just asking for a continuance to be able to respond to what they filed on Tuesday. I think that's more than
Have you responded to
fair.
the motion to dismiss yet?
I have not responded to the motion to dismiss. They filed it on Tuesday. What I did respond to was a correspondence that was submitted on January 2nd that talked about, not even really talked about the motion to dismiss, it was just a correspondence alleging that they hadn't got notice of what was proceeding. So I didn't get a formal motion to dismiss until Tuesday, this Tuesday.
Yeah, I mean, it seems to me that the very simple issue is whether a zoning status review, which is something that can be appealed. I mean, it seems like
Whether
it's
it
a very,
is.
whether it's appealable. It seems like a very simple issue.
Yes.
It's not a notice of violation. It's nothing that has ever come before us.
By an
I mean,
abutter.
and I've been, I guess, here the longest, so.
It's, and also, I just want to correct the record. All of my arguments in the motion to dismiss were in the January 2nd letter, and Mr. Mancini responded to that letter the very next day. This is, and I would ask, at a minimum, for you to just hear from the building official who authored this and what his intentions were about that document. There was a mistake, it seems to me that there was a mistake in distribution, and now all of a sudden it's on appeal. It doesn't make any sense.
If I may, and I'm sorry the back and forth, but I think the board can appreciate the significance of it because obviously whatever happens here as a quasi-judicial body creates a record, and that record then goes to Superior Court to be reviewed. So whatever decision is going to be decided here ultimately is going to be reviewed by the Superior Court. So I just want to have an opportunity to properly document what our position is going to be, and I want to be certain that the board has also had an opportunity to review both their argument and our argument. If they're calling for testimony of the building official, that's fine. I mean, I'm open to whatever procedurally they want to do. I just want to be given
I want to be given adequate time to be heard meaningfully and to submit what I think is important to be submitted. I don't think the request is out of the norm. And whether the document is labeled or it's not labeled, the impact of the document's important because it alters the rights of my clients who are property owners within the town of Narragansett adjacent to the subject property. So the decision, the lack of decision, the non-decision, the review status, whatever you want to call what the building official did, it has impact, and I think that is what has to be addressed. But I don't want to get into the merits of it until I've had an opportunity to explore the case law, to prepare a memo responsive to the motion to dismiss, which has been now properly and appropriately filed. Even though they haven't intervened in the matter, I'm not going to object as to whether or not they have standing or whether or not they shouldn't or should not intervene. I think they certainly are parties with appropriate standing to raise the issue of the motion to dismiss, so I'm not going to object to that. But what I am going to object is their ability to file something on a Tuesday and me not be able to respond to it on a Thursday, and to argue that I knew what their arguments were back in early January. The point of the matter is you as board members received something from the moving party on Tuesday, and me being the party who's actually appealing it, this is my appeal, don't have an opportunity to respond to that. And I'm not sure that the board has been able to review everything. And I think it's not an obtrusive request to ask for a continuance to comport with due process.
I don't know, Nick, how we proceed on this. To me, it seems like there's nothing to appeal because there's no notice of violation. There is nothing that has occurred that's affecting anyone's property rights.
That's where I'm at. It's no secret. I shared this with Attorney Mancini. I don't believe it's an appealable document. What he's raising before you, and that should be the end of it. What he's raising before you is more of a due process issue, so you should consider that if he should have time to respond. But whether the night is tonight or somewhere down the road, my opinion will be that it's not an appealable document. And I think you'll hear from Wayne, who may set forth some facts that would establish that. But what's before you right now is a continuance request that both sides have put on the record you need to make a decision on.
Any comments from the board?
I'm not voting tonight because you have a full quorum, but
I get the green light on there. There you go.
Hello? Okay. My feeling echoes our counsel here that this is a due process issue, and if we ultimately get to the motion to dismiss on the merits, I think he still has to have an opportunity, and in my experience, sending someone a letter is not, and sending back a response is not the same as a formal motion and opportunity to response, and I'm not sure anybody would be hurt if you were to continue this 30 days.
Anybody else?
If I may. Continuing it for 30 days is not going to work because Mr. Mancini's not available February. My client is not available March, April. This is my client's property. The neighbors to my client's property are manipulating the system that they have no right to manipulate. Mr. Mancini literally sent us a letter on January 3rd after my letter advising of the issues with the, this motion to dismiss, the jurisdictional issues, the very next day. He could have sent in something today. There's nothing new to argue.
Well, let me ask you this. I think we're having a special meeting. Is it next week?
Yeah.
Is it next week?
What date?
26th.
The 26th.
Well, that's going to be a snowstorm.
I'm sorry, I didn't hear you, Counselor.
No, I'm sorry, Mr. Chairman.
Yeah,
It's scheduled right now for the 28th, I believe.
Yeah.
Yes.
For the
So you do have a quorum for that day, should you need it.
Mr. Chairman,
Oh.
I can be available in February. My client can't be available in February, but if all you're doing is a procedural issue, I can handle that.
Well, why can't we do it on the 28th?
I can be available on the 28th.
I mean, that's plenty of time for you to respond.
Yeah.
And that would,
That's fantastic.
all right. Yes, how about we continue for that
Thank you.
on January 28th? Kind of,
We're okay with that. Thank you.
you bet, thanks. All right. We don't need a motion or anything for that, do we, to continue it to the 28th? Okay, is there a motion? Second? Who's second?
Second.
Ellen. All in favor?
Aye.
All right. Thank you. Yep, you bet. Let me just,
I'm sorry.
yes, yes, ma'am.
Clarification, just on the motion to dismiss. We don't have to
Yes.
be prepared for the substance.
Yes.
Thank you.
The next matter, which I think is being continued, is Gibson Court Condominium Association. Is there anyone here for that? All right, is there a motion?
So moved. I'll make a motion. Second.
All in favor?
Aye.
That's continued to February 19th.
Gibson Court,
Yes.
isn't it March 18th? Oh, no,
Oh.
I'm sorry.
Heidi? Okay. Never mind, I think we got it. The next matter, D2, is Nero. I think that one's being continued. Is there anyone here on that one? Mr. McGreen, how
I
are you?
represent Mr. Nero,
Yep.
and yes, we're requesting that be continued to the March meeting.
Okay. Is there a motion?
So moved.
Second? All in favor?
Aye.
Aye, March 19th.
Thank you.
All right.
I have the next one, too.
Oh, you do. The next one is Martino.
That relates to the text amendment, and hopefully, if things go right, I could be ready for the March meeting, and the ordinance will be changed.
Okay. So is there a motion to continue that to March 18th?
I'll make a motion.
19th.
I'm sorry, 19th.
I'll make a motion to continue it to March 19th. Second.
All in favor?
Aye.
Thank you.
Next matter up for, I think, continuance is Skybound Development. Mr. Surdet, how are you, sir?
Good evening, Mr.
Good.
Chairman, members of the board. Mr. Chair, you are correct. In light of some recent court decisions, we're revamping and looking into this application, so we'd request to be moved to your next meeting in February.
You want February or March?
I'm fine with February. If it's a full meeting, I'm
think we have a full-
happy to go to March. I defer to the board.
So, Mr. Chairman,
Yes.
so I believe your rules of procedures say if the applicant is asking for the deferral or the continuance and it's the second time, it moves out 2 months.
So it would have
So
to
it would go to March.
right?
I-
Okay.
I think it's up to the board's discretion.
It is
I
up
d-
to the board's discretion, and it's in your rules of procedure that it is.
All right, March 19th?
Thank
Do
you,
we
Mr.
have a
Chairman.
motion to continue it to March 19th?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Thank you all. Have a good evening.
All right. Back to the top. Robbins.
Good evening, members of the board. Attorney Dana Argente for the record, on behalf of Cal Robbins. I had discussed this situation in the hearing tonight on the appeal of both of the notices to appeal from September, notices of violation from September 18th and November 21st. I discussed it with your solicitor. The applicant has actually signed an alternative lease for alternative housing with the two downstairs neighbors. In light of that, we still have the special use permit hearing on the legalization of those two units, which will now not have any residents in them by February 1st. So we're going to request a continuance on this to March based on the fact that the special use permit hearing and final vote might influence these actual appeals themselves.
All right. Is there a motion to continue this to March 19th?
Moved, so moved.
I'll second that.
All in favor?
Aye.
Thank
Thank
you.
you, members of the board.
You got it. Okay, the next matter on the C2 is McCarthy.
Good evening, Mr. Chairman, members of the board. Attorney Matthew Landry on behalf of the petitioner appellant Michael McCarthy, the property owner. There are two notices of violation before the board, and we had consolidated these for purposes of the hearing because I think we can address both in one swoop. What I'd like to address first, if I may, is the issue with the pickleball courts. There was a notice of violation regarding the use and the nature of the 2 pickleball courts that exist on the property. The substance, and I don't want to speak for Mr. Pimentel, but the substance of the notice of violation was that it was being used for a private commercial recreational league, suggesting that he's operating a business for profit, that it's an organized league that members of the public can come and use. That term commercial is not defined in the ordinance, and I've discussed this with Mr. Pimentel, but it certainly implies that there's something more than just personal use, which would otherwise be allowed on the property. I want to stress the fact that my client had gone through a pretty lengthy process of tearing down the old single-family residence that was falling in disrepair. Went through a long process with the building department and planning department and knock down that house and build the house, the workshop, and the barn that's on the property. But there was a building permit issued by the town for the 2 pickleball courts. So the existence of the pickleball courts, respectfully, is really not the issue. It's the manner in which they're being used. The 2 outdoor pickleball courts are there. They were constructed subject to the building plans and the building permit, and a certificate of occupancy was issued by the town, and there hasn't been an issue since. So I think that's important because you've got affirmative action by the town that permitted these courts, and they're obviously incidental and subordinate to the single-family residence that's there. So that's point number 1. With respect to the commercial nature, my client uses this for family and friends. That's it. He's an avid pickleball player, has a small group of friends that are also avid pickleball players, and this is a place for them to gather on a semi-frequent basis to come to the property and use it. He doesn't operate a league. It's not advertised. It's not solicited to the public. It's generally the same group of people that come and play. There's ample parking on this property. It's several acres in size, so parking and traffic and those types of things aren't an issue. There's 2 pickleball courts there, so obviously the intent was to use them in some manner and capacity. I completely agree that if he was operating a formal, organized commercial league for profit, that would not be allowed. That's not what's happening here. He doesn't receive any money for this. There's no website. There's no advertising. It's family and friends only as personal use. I think the best way, respectfully, that I could suggest that this could be resolved is I've had my client review an affidavit that I drafted that says all of what I just told you. It states when the building permit was issued, when the CO was issued, and the manner in which those courts are being used for personal, private use only, not for profit, not for any organized recreational leagues, and it will stay that way. What I would like to do is have an opportunity. Mr. Pimentel hasn't seen this yet, and I think I could present it to him, to the board and to Mr. Pimentel to review it in draft form, and if acceptable, have my client execute it, have it notarized, and it would be on file. It would be an enforceable document and may provide some insurance or comfort to Mr. Pimentel from an enforcement side of things that these were the representations that were made, and unless he receives information that it's being handled some other manner, that may be the best way to handle that issue. Otherwise, I could have my client testify and say everything I just told you. Again, these were lawfully permitted courts. They've been there. There's several tennis courts in the neighborhood that people use for their own personal use. There's no limit on how many people can use them. He's got ample parking, like I said. So it's personal, family, and friends. That's it. There's nothing beyond that, and I haven't seen any evidence to the contrary. So that's the pickleball issue. I don't know if Mr. Pimentel wants to speak to that, but I do have copies of the affidavit that I drafted. If it's acceptable in form, we can have it executed and hopefully resolve that portion of it. Or if the board requires further testimony, I'm happy to speak on that. So before moving on to the separate issue, I don't know if Mr. Pimentel wants to comment or offer any context, or if that's an acceptable proposal.
Sure. Based upon what Attorney Landry just stated, The courts are legally permitted, and were done so under the original building permit. The citation was issued based upon complaints we received and screenshots of communication between Mr. McCarthy and some of the people that played there, which pretty much looked like it was depicting a formal league, a private league that was playing there. And we also got complaints about the increased traffic that was occurring at the site. But based upon the fact that, you know, there'll be an agreement that this is not for profit, it's strictly for personal use, I don't have a problem with that statement and a signed affidavit from Mr. McCarthy to that effect. And at that point, we wouldn't really have anything to pursue as a violation.
One moment.
Yeah, we do it after the fact.
Yeah. My only comment, the question I asked Wayne was if we keep this matter open while specifics are ironed out. I don't want to see something dismissed and then an agreement can't be reached and then you can't come back. So I think it makes, Attorney Landry is always approaching things in good faith. I think it's a good faith approach. I suggest the parties talk, but this matter should not be dismissed by way of example until that's resolved.
All right, the other question I have, which I think is purely a procedural question, is we've had these notice of violations before us several times in the past, and it's not clear to me whether people can speak in favor or in opposition to a notice of violation. I don't.
You know, it's a great question, because on the one hand, it's an appeal. It's administrative officer making a determination that's appealed by a party. On the other hand, we have an open public hearing. So maybe this is just me personally, I would always encourage more input, public transparency.
All right, well, given the fact that I can't be certain of it, but there's a lot of people sitting here, and I know what's on our docket tonight, so I mean, in the interest of saving all these people that may want to speak in favor or opposition to it, I think we should let them speak.
That's at the board's discretion, certainly. I can't object to that.
I don't disagree with that.
Okay. So are you, is that, well, go ahead. Any other comments?
I just have some questions. Some of the information that we have in our packet seems to show that there's this app that people have been on, and you're saying you're going to be limiting it to friends and family. I mean, it looks like the app has had upwards of 300 people that book pickleball time on this, on
Yeah.
these courts. I mean, I would love to have 300 friends and family, but, which I don't, I have none. But is there any way to, if we're going to have an affidavit, if there's going to be an affidavit and an agreement to limit it to friends and family, can we also, rather than just friends and family, is there an amount we can limit it to at any one time? Is there, it just seems like.
If this is something that's going to be worked out outside of the purview of the zoning board, I think that's something that Wayne would look at. If it comes back before the zoning board, you certainly would have input on any type of resolution.
Right, I just, the evidence sometimes, I mean, seems to think that there's people that, 300 people on this app booking time on these courts. So I'm just trying to.
I mean, this is why I think we need to hear if there are any opponents out here to see what their perspective is, and maybe it might change Wayne's mind. I don't know. I'll get to you, sir. Does everyone agree to that?
Open it up, yeah.
All right. Do you have anything else, Mr. Landry? or-
No, I just would reserve any, rebuttal comments once the public is spoken. And I'm sure this is something that we can work out and address concerns with use of an app if that's the case. I mean, I don't think this needs to be a heavy lift. My client's being reasonable about it, and his intentions are clear. So I think it's worth hearing from the public, and then we can work out any conditions or details that we need to.
Thank you. I guess, are there any proponents of this appeal? Are you a proponent or an opponent? Okay, there being no proponents, are there any opponents of this appeal? Are there any opponents to this appeal?
Yes. Dan Harding, Harding. Thank you. So how you doing, folks?
Good, how are you?
My wife and I, my family live on Gibson Avenue, right in the middle of, when dirt road starts, there's one neighbor, the Gerasi's, there's us, the Goodwins, and everyone else in the back. I find it funny to hear that it's being used for personal use, which I've talked to Mr. McCarthy about that. I have no problem. I mean, why can't you use a pickleball court? You build it, go ahead and use it. But when the traffic started to pick up, and it picked up significantly, we've been there 21 years. A lot of us been there more than 2 decades. It started picking up to the fact that, we were going, what's going on here? And then one of our neighbors said, oh, they put a pickleball club on the internet. And, I'm glad you mentioned that, over 300 members. And I asked Mike, would you take that down? And he said, I could do what I want, and whatever. And then he eventually did take it down. But unfortunately, the damage is done. There are so many people in this town that know that there's a free place to go play pickleball. They come down the street several times a day just to see if anyone's playing. So we went from solace, raising a family, to random people. He doesn't know all of them. I can promise you that because I've stopped and talked to some of these people. Who are you coming to see? We're coming to play pickleball. Okay, do you know Mr. McCarthy? Oh, we saw it online. So that, I understand the personal and family, no problems with that. I've told him that straight up. Just be respectful for people who live here and don't abuse what you have. He's got lots of money and this and that. He can do whatever he wants, and that's the attitude, and it's unfortunate for us. We are bearing the brunt of it. So back to the damage is done. I don't know how, anyone's going to police now people just coming down, because all that has to be said is I'm his buddy. And so we are stuck with a public facility behind us that we have no control over. My neighbors and I maintain the road. It's a road, it's a right-of-way. It's not a town road. There's a lot of disrespect going up and down that road from these people, going over our yard, whatever it is. And again, we've got children playing games. We play in our front yard, and we've been broken in since this has happened too. It's on the police reports. Someone came in our house, my wife and I were gone. Magically, after all of these people are starting to come down, and my understanding too, there's been some college kids inquiring. I don't know if they come down there, but from our perspective, it's just out of control. It has stopped because, it's wintertime. He does have an indoor court, so they go inside. So there's 3 courts. There's not 2. So they go inside and play. That was in the fall. But now, we haven't seen any activity, and everything is fine. It's great. He does his business, we do ours. So just wanted to have you hear how we feel, how it has impacted our life here in Narragansett for 30 years.
Can you clarify one point for me? Because we do get a packet of information. Are there 2 courts inside and 1 outside? Or
Well, the plan, there's 2 outside.
Yep.
And they were there. We're all like, oh, look, he's got pickleball courts. He had some friends, and there was a summer when they were first, they play, and we are all like, hey, they're playing pickleball. But then, I guess not enough friends or people to come play. Let's put a app out there and have, now we can have parties. And on that app, or whatever, it says, bring your music, drinks, coolers, bring it all. We'll all have a good time. And these are random people. So that to me is a public facility. We're not charging. That's a loophole. He doesn't need the money. So that's my feelings.
Any questions?
Thank you.
Thank you. Anybody else who's an opponent that would like to speak?
We're here for the same reasons, but
But-
Dan has...
Come on up if you want to. We have to swear you in if you want to say anything.
Please raise your right hand. Do you solemnly swear that the
Yes, I do. Please state your name and spell your last. Lisa Goodwin, Goodwin. We're here for the same reasons, but Dan, we've shared we have similar feelings about the situation with the pickleball. We were going to reserve our commentary for the bus situation.
Okay,
Okay?
very good, thank you. Anyone else? Come on up, sir.
I do. Gene Piscator, last name's P as in Peter, Iskator. O-R, yes. I'm in a butter. I live off of Gibson, Kendall Court. There's some other folks here from our little subdivision. Same thing, we noticed the increased traffic. We wondered what was going on. We just have, well, one thing, definition of a friend from Webster's is the folks that are showing up are not definition of a friend. They have something common, some affinity, some, previously met. And the second thing is, I don't know how the representative wanted to handle it here offline, but the procedure is there's a notice of violation, you determine it's violated, and then we go from there. Handling it offline seems like it's short-circuiting it. You should handle it online through the notice of violation, and then if it happens again, we handle it that way. So that's all. Thank you.
Hold on, any comments from any of the board members? Questions? Are you a opponent or proponent?
That is my client, Mr. McCarthy. I'd
All
like
right,
to comment
well,
on it.
You might want to talk to your lawyer first.
Do you want to speak?
Come on up, you have to be sworn in, sir. Wait a minute.
Michael McCarthy. I do. Yes. Okay. So, yes, I put that app up, and I would say maybe over in the 4 or 5 months, maybe 5 of 6 or 10 people over time kind of came, and most of them just played one day, and then that's it. And then I have I've met some friends, and we play, and that's it. Mr. I can't remember his name, asked me to take the thing down, and I did, and it really wasn't doing anything anyway, but I was willing to do it, and that's it. Thank you.
Hold on a minute, sir. What was the intent of creating an app for these pickleball courts you had?
I didn't create it. There is an app that somebody showed me at one point and said you can put the OSB people are on there, and the other ones that are commercial. So,
do you know how many people signed up for your app or signed on to it?
oh, very, very few. Very few. Occasionally, somebody would come as a result of seeing it, but other than that, it was mostly a group of my friends that were of similar skill sets.
Were there people that signed up that you didn't know?
Sign up?
Well, were there people that signed on to this app?
Nobody signed up.
Or
Nobody
whatever
signed.
it was.
Nobody signed to the app.
All right, well, what were you going to do if 100 people showed up at your house because you put out a notice that people could come and play pickleball?
Well, I did put it out, and a few people came over that whole period of time. There's nothing, really. I mean, there's not, there weren't any, almost just a few people.
Any other questions? Go ahead.
It wasn't, it was just, I'm just looking for people to play.
So you mentioned that your OSP people, is that Ocean State Pickleball?
I'm sorry?
You mentioned OSP people.
Yeah.
Is that the Ocean State Pickleball that's in town?
Yeah, the commercial one down on.
Right, and so
There.
you knew people from Ocean State Pickleball. A lot of these people that came to play at your pickleball courts did you know them from Ocean State Pickleball?
No,
No.
I didn't play.
Okay.
I wasn't good
Okay.
enough to play over there.
The information that we have in our packages, and I'm just going to tell you what it says. It says that there's 271 members of your group, which you've called Gibson 3.5 plus pickleball or something like that. This is what you set up on your app. Looks like there's 271 members that are members of this group that can play or can.
They may have signed up, but
Right, you haven't seen them at your place.
I don't know.
You haven't never had, like, what's the most you've ever had at your house to play pickleball?
Oh, gosh. I mean, there's, well, with two courts, you're, I don't know,
people.
maybe
8 people, 2 courts?
8 people or 12 people, maybe.
3 courts, 12.
Yeah.
But they may have like a tournament or something. Okay, so
Minimum,
nowhere near the 271. I guess, is it true that, like, that nowhere near 271 has played on your courts? It's just, okay.
It was always, most always
Okay.
friends, my personal friends.
Okay.
Go ahead, David.
The app is Team Reach. My wife plays pickleball. We don't know you, we've never met you, we're not relatives. She was messaged through the app to come play because she's above 3.5. So anybody who's on that app that's above a 3.5 is free to come on there and try to schedule time to go play. And we're not relatives, we're not friends, we never met before, so.
I'm not looking for, I don't want more than
I'm just
8
saying that she was
10.
invited to come play.
Yeah.
I've never met you before in my life, we're not relatives, so
Yeah.
to say that it's just family and friends is really not totally correct in my mind.
Well, if somebody signed up on the app, that doesn't mean that they ever came to play with us.
Yeah, if I can just interject, so I'm familiar with, I didn't have that information that's in your packet, I wasn't even aware of it, but I am aware of the app. The app, anybody can favorite, a court location. It's really for people, even friends, people that you know, to find times and people of similar skill levels to play. I think the testimony from Mr. McCarthy is that, 5 to 10 people over the course of several months came, and it's no longer up. He took it down, or will take it down if it's of concern. The violation was related to a commercial league or organized league. Team Snap or Team Reach is not a league app. It's not for profit. It's literally just people in the pickleball community looking to play with others on a friendly basis. It's not commercial in any way. I'm not sure it runs afoul of what the violation was, but certainly if it amounts to commercial or solicitation, then you won't do it. We can condition that if that's a concern. The 241 people certainly has never been anywhere near that amount on Mr. McCarthy's property. It may be that that's how many people favorited, that link or something, and doesn't mean that they played or he ever even met them or spoke to them. But I don't think it has to be family and friends either on the way the ordinance reads. It can certainly be, acquaintances and people that he knows in his circle that he's invited as guests. It doesn't amount to a commercial recreational league, but to the extent that soliciting it on an app amounts to more, then I think we can agree with that.
Mr. Landry, let me ask you a question, though, because I played USTA tennis, and I would go onto an app to find people to play against. But it wasn't always directing me to your client's club or courts, you know what I mean? It would match us up, and we would be able to say, let's play in Providence, or if we wanted to play clay, or play in Newport on grass, or whatever. So it's kind of different, isn't it? These people are all being directed to his facility.
Well, it's a meetup, location on where to play. He's not receiving a profit from it, and it's not an organized league. The way I read the ordinance and the way it was cited as a violation was that this was a commercial operation, Lake Ocean State Pickleball, which it clearly is not. There's no profit, there's no organized league play, it's like-minded individuals playing. It's no different than him asking somebody that he meets if he'd like to play pickleball at his home. I don't think there's anything wrong with that. But I do agree that it may rise to a different level if it's open solicitation on an app. I think that's fair, and he's no longer doing that. And if that's something that we need to be mindful of in any conditions, I think we can agree to that. But I don't think we can restrict, acquaintances and people that he meets in the pickleball community and invites them to his house. I mean, I think it would be a stretch to infringement on his property rights to have a guest come over that he wants to play. But to the extent it's solicitation, to come and play, then maybe that crosses the line.
Can I ask a question?
Yes.
Did I read somewhere that anybody that was on that app could show up whether Mr. McCarthy was home or not? Because he's saying maybe it was 5 or 10 people, but is he always home? Or can people just show? It looks
I'm
like
not aware of that, but I would.
Looks like it said like 8 a.m. or 9 a.m. on the weekends and then till whatever time. So it sounds like people can just show up whether he's home or not and you make use of the court whether they know him or not.
I would highly advise him not to do that if that was the case, because it is his home and they are his guests. So, to the extent that happened, we could agree that that can't happen in the future.
And then one other question. So there's 2 courts outside. Is there how many courts are indoors?
2.
So 2 indoor and 2 outdoor.
Originally, there was 2 inside as well, but I have equipment and things and other stuff inside the building, so there wasn't room for that.
So there's no room to play inside, or just only outside?
There's 1 court.
1 inside? Okay.
Oh, okay. So originally there was 2, but now there's 1 indoor and there's 2 outdoor.
Correct.
Okay, thank you.
I have a question. In the material that we received, it looks like Mr. McCarthy on August 2nd at 6:16 a.m. posted on the app that we can accommodate 8 to 14 players. So would that be players per court?
No, I think that's total, because generally you have, 4 people to a court and maybe a rotation, two people on each side. But that's total. That's right?
And typically a game is how long?
We played a 13, is that it? How long does it get, 30 minutes?
11, or it depends on the game.
Okay, so just to try to determine how many people can be circling through in a given day on 4 courts, just to address, the amount of traffic and the information that people have been providing, it could be a significant number. So, that 271, maybe they haven't been there all at one time, but over time, circling through those courts, would the numbers be that large?
There's never any really more than 12 people at a time on the property playing pickleball.
I mean, if somebody signed up, that doesn't mean they ever came.
Yeah, again.
And it really wasn't. I mean, most of it was my friends. It was very unusual that somebody that I didn't know showed up.
Okay, thank you.
Any other questions?
So I would go back to my original suggestion. I think there's some things that we need to address and concerns. I've heard traffic, I've heard, the amount of people, I've heard the app. I don't know if it's something that we should discuss in more detail here, or if it's something that we can work out with council and Mr. Pimentel and present a draft to him and then for the board to review. I imagine if Mr. Pimentel is satisfied with the conditions and how we drafted to address these concerns that came up, hopefully we can resolve it, but we'll leave it open so that way it's an open forum and everybody understands what's being discussed. That would be my suggestion.
I just have a comment. If we're going to leave it open, Nick, and there's an affidavit presented, shouldn't we leave this open so that the opponents to this can see what's in that affidavit? And
I have no objection to that.
How long can we leave it open?
Similar to continuing the public hearing, there's an opportunity where the parties may get together, work on a potential resolution, but it could be, there's a number of matters tonight that could continue, is the short answer.
I guess I'm just wondering if we can leave it open through the summer, because you're not going to really see too many people playing pickleball outside right now, right? Or I don't play pickleball, but.
Now you're testing me. I know
All right.
that there's a provision in state law that requires, but if you have the consent of the applicant, it could be continued, although the competing interests of these other folks who live there might want resolution.
yeah, I think we need to get a prompter resolution than the summer, for sure. I mean, it's not fair to the people that are here objecting. You have any suggestions? I think it's on.
No, not you, me.
Oh.
My only concern is that,
You're talking to the mic.
my only concern was that the neighbors aren't going to really see if the affidavit is being complied with until the summer. Even if we, agree to have an affidavit or a statement as to how the property is going to be used, they won't really notice the effects of it until the summer. That's all. But if we can't leave it open, I get it.
I think the long and the short of it is, Mr. Landry says he has a proposal that he wants the person who issued the NOV to consider. I think we continue this, I know there's another portion tonight, continue this so that could be considered. Wayne doesn't know what it's in it, I don't know what's in it, nobody knows what's in it. So I think we take that step and then appropriate steps thereafter.
I mean, I'd be okay with that, with the exception that I think we need to be fair to the opponents of this, that they have an opportunity to be heard on what's in that affidavit, because I think as someone testified, it's really going to be a matter of enforcement. And, you can say this is not commercial, but it's darn close to the line. I don't know. That's just my thinking on it, but I think I would be agreeable to that if the rest of the members are, if they are all given, they get an opportunity to see it before the next hearing and oppose it.
Yeah, and I'm happy to share it. Maybe easier for me to share it with the town, and then if the town has a copy, they can share it on request by the public. But if someone wants to contact my office, I can share it too. It may be easier to have one channel, but I don't object to that. We want this to be an open dialogue, but I'm also trying to protect my client's rights and interests. He's not operating a commercial league, respectfully, but I think there are parameters that we can stay within that would protect everyone's interests. And that's what we're trying to do here in good faith. We're trying to put something in writing that is enforceable, that Wayne can enforce, that's clear on the use, and that way going forward in the summer, if there is something that deviates from that, then it would be another notice violation.
So is there a motion to continue it to what, the February calendar? Can we squeeze it in there so that we don't have to have a big delay here? I'll work late even.
We can certainly try and squeeze it in. The date would be February 19th.
Is that acceptable to?
I am actually away that week, but I am confident I could have someone from my office attend in my stead. If for some reason that's an issue, I'm going to be traveling away. It's school vacation week that week, so my kids.
Appreciate that. So I think, just to be fair to the opponents, can you agree to get that affidavit to Wayne or whatever, at least
I have a
week or two
draft.
before the hearing, so that everyone can have a chance.
Oh, yeah,
to look.
I've got a draft already, and I'll propose some additional changes, within the next day or two, and we can go from there.
All right, can I have a motion to continue it to February 19th?
Motion to continue, motion to continue to February 19th.
Second?
All in favor?
Aye.
Okay, thank you, Mr. Landry. I know there's another part to this, is that right?
There is. Thank you for your indulgence on combining these for the same hearing. This notice of violation came, I think it was in November of 2025. There was a lot of discussion with my office and Mr. Pimentel back, I think, in April or May of last year. That's how long this thing had been lingering. It presents a couple of unique issues. The NOV cites storage of commercial vehicles outside, which is prohibited in a residential district, and also cites my client for general automotive repair. And I drafted a fairly lengthy letter to Mr. Pimentel stating the grounds as to why we didn't think, it was a violation. And, there was some back and forth about trying to understand what was happening on the property. And ultimately, it resulted in this NOV that we appealed. So my appeal letter has that original correspondence. I think it's from May of 25, and it's pretty detailed, but it essentially is two grounds. One is that this is really an incidental and subordinate accessory use to the primary structure, or it's classified as a home occupation. And there's a number of standards in your ordinance that discuss that. Garages for commercial vehicles are allowed as accessory uses in the district, but I don't even think we need to get there. A little bit of background is my client is an advocate for animal rights and started a very successful nonprofit organization that's based in Texas that deals with displaced animals and relocating them in storm events and major tragedies and things all over the country, all over the world. And in connection with that business or the nonprofit operation, there are these vehicles, these old school buses that are retrofitted for kennels and services for these animals, and they're shipped all over the country. It's really a beautiful thing. He's well known in the animal rights circles. I say that because it's a passion project, but it's also a hobby that he does and devotes a lot of time to. I imagine he was cited for parking of commercial vehicles because someone saw a bus entering or exiting the property, or it was stored outside for more than 24 hours, as may be the case. What's happening in the property, in his warehouse garage that he has that's attached to his residence, no more than 2 buses the whole year are on the property for more than a week, maybe 2 weeks at most, ever. He leases an off-site storage location that actually parks these vehicles long-term. So they're not stored on the property, and that, I don't think, was clear at the time this NOV came along. So he's got a commercial site in Wakefield that he keeps these buses and parks them, so they're not staying on the property. And they're very intermittent, 2 at most the whole year. And all that's happening is not general automotive repair, but more retrofitting fixtures like railings for leashes and, beds inside these buses, maybe a seat, and really for kennels, retrofitting it for these kennels so they can get shipped all over the country. That's it. That's all that's happening. There's really nothing more that's happening. He doesn't have any employees. He's got a volunteer that may help him on occasion. And all this work is happening inside the building. So that's really it. I find respectfully it's akin to somebody working on a sports car or a muscle car that may be a hobby that they have in their garage, their personal garage, and is using it. Again, this is not a nonprofit. There's no money being had. He's not selling these vehicles. He's not turning these over every day, every week. And they're being parked at an off-site location as is proper. So that's the extent of it. I think it's an incidental accessory use. It's really not a big thing. If you drove by the property and it was happening inside, you would never know. There's no advertising, there's no signage that, you know, it's a single-family residence that has a garage. So on that latter point, I also raised the issue of a home occupation, and you've got, you know, 6 or 7 elements that you've got to satisfy to be a home occupation. If you don't find it qualifies as an accessory use, or Mr. Pimentel doesn't feel it qualifies as that, home occupations have to be limited to 25%, you know, I think it's the first floor of the dwelling. We did that calculation in my letter. It's 1,600 square feet, I think he has to work with. You can have up to 1 employee, you can't advertise, there can't be any structural modifications to the home. And I went through that analysis in my May correspondence, how he satisfies each and every one of those elements. You know, no noxious odors, you know, signage. If you're driving by, you wouldn't know that it's there. So on those 2 grounds, again, respectfully, I think it is really a benign activity. Again, it's 1 or 2 buses at most, 1 or 2 times a year at all, and these are parked off-site at a different commercial location in Wakefield. So that's it. I mean, I think, you know, if these things are being stored at length outside, you know, commercial vehicles, your ordinance does allow parking of commercial vehicles up to 12,000 pounds, and even tow trucks, and, you know, I went through that analysis that there is some parking allowed of some type of commercial vehicles here. I'm not suggesting that we need to comply with all of those. This use is happening interior to the building. I think it's both a home occupation and an incidental use. It's a hobby. And no general automotive repair is happening on these vehicles. I think that's an important point. But I do think somebody working on a hobby vehicle could change the oil and brakes if they were akin to that. But this is more retrofitting these vehicles with kennels and, you know, fairly benign things that can be done in a couple of days, and that's it. So again, I think the substance of our appeal is in that original letter. You know, I can go into more detail, but again, if we need an affidavit, sort of the same exercise to outline what the restrictions are, and it's an understanding of what exactly is happening, and we stay within those parameters. Good faith effort. We're trying to resolve this here and make sure everybody's under the same understanding as to what's allowed and what's not allowed. So I just offer that suggestion again, and I'm happy to work through that. Of course. I think so. You know, I don't have the number at the top of my head. I used the field card to get the square footage. I think the 25% number I came up with was 1,600 square feet, because I think it's 25% of the first floor of the dwelling. I'm sorry, I don't have the numbers off the top of my head. Well, so the residence and the garage are all in one barn-looking structure. The calculation I did was based on the residential portion of it, you know, the square footage of that calculation. I backed into the numbers to know that we were at the 25%, and the square footage he's using for these vehicles is within that range. I think my May letter has those calculations. I apologize, I don't recall them off the top of my head. It was a while ago. It is, yeah, I think it's raised. It's sort of, half of it is a garage, and then the other half is on the right-hand side, sort of upper story. And the building permit, you know, classifies it as a single-family residence, barn, workshop, and, you know, pickleball courts.
All right, so I guess I'm trying to figure out, the reason why I'm asking is one of the things that you cited in your letter says the occupation does not utilize more than 25% of the floor area of the first story of the dwelling unit. So what is the first story of the dwelling unit? What is the square footage of the first story of the dwelling unit?
So I think, looking back, it's the whole building is considered a dwelling unit because it's one structure. It's got an interior garage. So if I recall correctly, I used what the tax assessor classifies as the square footage of the first floor of the building, which is 3,000, whatever it is.
200.
Yeah. And that, again, is only if, we have to get into the category of a home occupation. I still think this would qualify simply as a insubordinate accessory use. I use the home occupation because I think we satisfy that standard, but it's either or it's both. I think you could find either way that it satisfies both those standards.
Is the foundation a national organization? The Rescue Foundation?
It's a 501c3. Its principal place of business in Texas.
Do they operate nationally?
They do, yeah.
And this is the headquarters?
No, it's not. No, it's not. No, the headquarters and place of business is in Texas.
Okay.
This is his residence, and this is something he operates, locally to this extent.
Is he affiliated with the 501c3?
It's his.
It's his 501c3?
Yes, it is.
That operates in Texas?
Yep.
Okay.
It's MGM Animal Foundation doing business as Animal Express. That makes sense.
Are they licensed to do business as a foreign LLC or company in Rhode Island?
I'd have to ask my client. I don't know that offhand.
Mr. Landry, you mentioned that you would be willing to supply an affidavit again. Would that affidavit say that there are no paid employees on the premises?
Sure.
That they're not operating a business there? Because it appears from some of this information here that there are employees and that there is even an ad here that Mr. McCarthy had published trying to hire an employee for the business.
Yeah, that may be whether or not it's at this location. We can clarify. You're allowed under the home occupation statute to have at least one employee. These people are volunteers. Again, it's a 501c3, but to the extent we need to clarify for the town if there are employees and how that's working, we can certainly do so. I mean, I know my client does a lot of this work himself. He enjoys doing it.
I have a question about the buses. The buses, are they registered to MGM or are they registered to Mr. McCarthy?
Is that, Michael, are the buses registered to you individually or are they to the foundation?
Testimony?
To the foundation.
Thank you. So the foundation they don't sell the buses, they use the buses to transport animals in need.
Yep, he supplies them to the foundation to go wherever they need to go, and they utilize them all over the country.
Thank you.
Sure. I just want to kind of clear up. I know since the initial violation back in early spring of last year, you had sent me the correspondence on the home occupation, which I think we kind of agreed that it fell under. Since that time, there was an uptick in the amount of work being done on the buses on the property, both the number of buses on the property at one time, but also work taking place outside of the garage area by either employed or volunteers with grinding equipment and so forth. And also, we had reports that they were painting the buses on site, which led to complaints about fumes. So I think if there's going to be any kind of affidavit, perhaps those issues could be addressed. So down the road, if there are any issues, it's easier for me for enforcement.
Sure, agreed. I think we can work that out.
Any other questions? Mr. Landry?
Thank you. And just for the record, Mr. Pimentel, what I'll do is I can reach out separately and just make sure I capture all of your concerns if there's any other ones, and sort of follow the same process if it's the board's pleasure. Present a draft that we think is agreeable. Members of the public can see it, and we can go from there.
So again, we're going to allow the public to, I guess it would be just before you leave, would you agree to the same procedure if there are opponents, which I suspect there are, that you'll get the affidavit in to allow them time to comment? We'll keep the hearing open just like the first one. Does that make sense?
Yeah, absolutely.
Okay. Are there any proponents of this appeal? Hearing none, are there any opponents? I think you should, because it's a separate hearing, yeah. Yeah,
Oh,
sorry.
okay. I do. Lisa Goodwin, Goodwin. We've been dealing with this for quite a while now. I grew up on this property. My grandparents were the original owners of the property that Mr. McCarthy now owns. We tried in good faith at the beginning of the relationship with Mr. McCarthy to act in good faith. We were away on vacation when he originally wanted to move into the property with a tractor-trailer truck. And we agreed to let him cut down a tree on the corner so the tractor-trailer truck could come in. Little did I know it was going to continue with full-size buses a few years down the road. These are not small buses. These are full, I believe they're called Type B buses. They weigh way more than 12,000 pounds. I believe they weigh upwards of 20,000 pounds each. So it is not a benign use. I actually really take offense at that. Not a benign use of the property. It's offensive. It's a calculated. This whole project has been misrepresented, I believe. Originally, it was supposed to be a pickleball club in his first application to you. That was shot down because it was a residential area. So they changed their tactic. It is an 80 by 100 foot structure. It's a commercial structure masquerading as a barn in name. I invite you all to come down and take a look at it. It is completely out of keeping with this beautiful natural area that has been in my family since my grandparents worked for Mrs. Hazard at the castle. It's a shame that it's there. It's a shame that our zoning regulations allowed it to be there. Yes, he is, under our current zoning rules, he is allowed to build it, but it's completely not in keeping with the property. I've been awakened at 2 in the morning with a bus leaving in the middle of the night with air brakes right in front of my house. We have people coming in, being dropped off to drive these buses places. It is a great organization. It should not be in a residential zone. I applaud him for what he's doing. It's a great organization for animal lovers, and he does save animals, but not on the end of Gibson Avenue. He's had at least six buses there at a time. He's painted outside, as you said. We've included that in our complaint. They are welding, they're grinding. We have had, my husband has more details about this if you'd like to join me, but one afternoon a huge tractor-trailer truck came down with a full container on the back, shipping container, and we watched them offload 28 pallets of dog crates. 28 full pallets. Tell me that's a benign use of the property. I don't think so. This whole thing could be solved if he would just move his commercial work out to wherever he is. I don't know, Wakefield. It's unfathomable that this would happen in one of the last beautiful areas of Narragansett. And our zoning laws allowed it to happen, and they're trying to exploit them right now. So, let's see. They both, it crosses with the pickleball because he moves the buses out of the way so they can play pickleball. I mean, it's just so egregious, it's ridiculous. I actually think, they play for free. It's better than it's actually worse, that loophole of it's not a commercial business because they aren't charging. He doesn't need to charge. He doesn't need to charge. He wouldn't, that's not the idea of the business. If you want to call this dog business a hobby, we can argue all day whether it's a hobby. I mean, my hobby is planting dahlias, but if you're, able to afford to supply 6 buses to animal rescue organizations, then I guess you could call it a hobby. But the bottom line is the buses are overweight in our zoning regulations, and that right there should be disqualifying. Thank you.
Thank you, Mrs. Goodwin. Is there anyone else who wants to speak in opposition?
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and spell your last.
Dan Harding, Harding. I just want to quickly say that, I agree with everything Lisa said, everything she said, we've all witnessed. We've confronted Mike, we said, hey, listen, what's the deal? Hey, it's a nonprofit. And again, we do commend him what he's doing, but this could easily be solved by moving his operation to a proper commercial property, which he already apparently is renting or whatever, or find another one, because there's plenty of funds, I'm sure, to do that. And then the volume of buses, we put this complaint in. Dan, last one, this is the last one. 1 week later, 3 different color buses, 4 came down, a yellow, a white, and a red. Boom, and then one other red one. They all truck down, all of them at the same time, go back there, boom, 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 come out red. They come out from white to red. They're doing the work in there, they're spraying the paint, they're doing whatever they gotta do, just like a body shop. I would call it a body shop. So, that's all I gotta say.
Thank you.
Thank you.
So are we going to do the same thing? We're going to continue this until, Heidi, can we do it on the same day as the other appeal in this case? I mean, we're holding that one open as well.
Yeah, it'll be heard just like tonight.
Okay, so that was on, February. I have a motion to continue it to February 19th.
I just have a question. What is, so they're going to work out some agreement?
Well, I think what Mr. Landry is going to do is present an affidavit to Nick and Wayne, or either of them, make sure it's in sufficient time for the opponents to weigh in on it and appear here to object to it, and then it'll be before us on that night for a decision whether to affirm or reverse the notice of violation.
Yep, I think that's.
Can you give me an idea of what the affidavit might say?
Yeah, there's some other allegations that I am hearing for the first time, and I respect and I'm sensitive to the public comments. I mean, if those are issues, if I haven't seen those as notices of violation, I don't know if there's been reports of that. Excuse me, if there have been, I'm happy to take a look at that and confer with my client. But the affidavit will represent what I've represented to you tonight in good faith, is that we want to keep this within the character that it's supposed to be in and within the confines of the law, that we can discuss what those conditions are and how we can frame that. So, the frequency of the buses, if there are employees or not, what the nature of the business is.
Will the affidavit say how much the buses weigh?
Will the affidavit what?
Will the affidavit affirm how much the buses weigh?
Yeah, if it's necessary, sure. I have no problem.
I mean, if there's some,
Well, the ordinance says it can't be in excess of 12,000 pounds, right?
That's for exterior storage and parking in excess of 12,000. To the extent it's relevant for the interior of the building, I can certainly work that out. I'm happy to put what we need to in here to satisfy everybody's concerns, as long as it doesn't impair with my clients.
I'm not sure you can say that it's less than 12,000 pounds.
No, and I'm not suggesting that they are. I don't think it matters if they're over 12,000 if it's inside the garage, because it's a home occupation. I think there's ways we can get around that, but I'm happy to work those issues out. And so the affidavit will reflect the statements that we've made, the understanding, and if there's any other concerns that we need to address, these other issues, if it's deliveries and other things, as long as it doesn't infringe on what my client does have a right to do, I think we can find a resolution.
Under the home occupation ordinance, item E, occupation does not produce or emit offensive noise, vibration, smoke, dust, odors, heat, or glare, radiation, radio or television interference, or other nuisance. Based upon some of the statements that we just heard, it sounds like it may be violating that section of the home occupation?
Yeah, again, I wasn't aware of any of those allegations, and I don't think it's been documented, and that wasn't the source of the notice of violation. As I understand from Mr. Pimentel, there were other activities that took place months after this NOV came out, and I'm happy to address that and review that. And, you know, and I agree that that is a condition, and it can't violate that for purposes of the home occupation. So, you know, again, if it's not a home occupation, I still think it's an accessory use that's permissible, but we can define the parameters that he has to stay within so it doesn't run afoul of what is allowed.
Isn't that the testimony that's being offered by the proponents just evidence that there's a commercial operation here ongoing as opposed to an accessory use?
Well, you know, respectfully, that's their, you know, personal statements. A lot of these things, I haven't seen any documentation of any of that. I have the documentation that I know about and that my client has provided. Ultimately, it's up to Mr. Pimentel to determine whether or not it violates the zoning ordinance, if it's a home occupation or an accessory use. The two issues that we were violated were that it was outdoor parking of commercial vehicles and general automotive repair, both of which, you know, I've laid out the grounds why we don't think it's either of those things. To the extent that there are activities happening that, since the NOV came out, that amount to that, if it's painting of vehicles or whatever it is, I mean, it's up to Mr. Pimentel to determine if that's runs afoul of the regulations, but to the extent we can provide an affidavit in support for what is happening and what will happen that limits some of those more egregious conditions that have been alleged, then, you know, we can address it.
But, I mean, just to be clear, I think he did make those determinations. That's why we're here, right? Mr.
Well, this,
Pimentel did make those determinations.
you know, the painting and, you know, the number of vehicle, all that's news to me. I haven't heard any of that. That wasn't provided to me. I'm going based on an NOV that's quite a bit old. I mean, this issue came up in April and May of last year, and we've been working through these issues. I think we did come to a consensus that it was a home occupation, and it sounds like maybe other activities have occurred since then that may be running afoul of what that original discussion was. And I no disrespect to Mr. Pimentel, I totally respect his position. If that's the case, then we'll work it out. When this originally came up, that was not the case, and when I filed this appeal, again, if there's other activities that exceed even the limits of a home occupation or accessory use, then we'll address those. And I think that's the best way to approach it.
Have you been notified of the buses and the weight and the heavy equipment being used and the late-night noise or the early morning noise or large deliveries that don't seem to mesh with a residential use?
I was not made aware of the weight of the buses. Basically because they were commercial vehicles is what they were cited under, and the general automotive repair, you know, some of the welding, the painting, that all fell under that. So to Mr. Landry's defense, he wasn't specifically notified of each and every one of those. It was just general automotive maintenance or repair that was being done on site with the buses.
If I could just jump in, could you just put on the record what the complaints were? I don't think you set forth the basis upon which you issued the NOV. I'd just like that in the record.
Yeah, the second NOV, there was a complaint taken on November 18th, and that was based upon photographs and written complaints that were forwarded to my office relative to the number of buses that were being worked on and repaired outside of the main structure, which is the combination of his home and a storage garage. There was also complaints about them painting, the fumes emanating from inside the facility from painting the buses, as well as grinding and welding that took place on the outside during good weather on the buses. And, you know, the delivery of crates associated with this nonprofit business that would be delivered to the site and then stored inside the garage. And I would assume that these crates would be loaded onto these finished buses, and then they would be delivered to wherever.
All right, so is there a motion to continue this to the, what? I'm I'm sorry, I didn't hear what,
Do I have an opportunity to rebut?
I mean, yes, please come on.
It's relevant. Do I need to do it again? Lisa Goodwin, Goodwin. Express.org, contact information, 170 Gibson Avenue, Narragansett. It says nothing about Texas here. I mean, maybe the nonprofit is registered in Texas, but the contact information for all of this and all the potential rescue partners are 170 Gibson Avenue. The barn structure is 8,000 square feet. It's 80 by 100. I think that's misrepresented in Mr. Landry's letter. And it's over 75% of the first floor is a workshop. And then what Mr. Landry just said, he can park these vehicles, these buses, if they're overweight, can be parked inside. How do they get there? They still have to drive by my house across my property, which has the right-of-way on it, which is a dirt road. It's really a dirt driveway. It's not even a road. So it's so egregious. I invite you to look at the website. I invite you to come down and take a look at this so you know what you're talking about when you're dealing with this firsthand. It's quite shocking when you drive down our driveway. Thanks.
Okay, we have a motion now to continue this to the February 19th calendar with the conditions that were put on the record.
I'll make a motion to continue it to the February 19th meeting.
Second?
All in favor?
Aye.
Opposed?
You're opposed? Okay. All right. Alicia, do you want to rest those fingers for 5 minutes? Okay. So we'll take a little 5-minute break while the stenographer recovers over there. Back on the record now. The next matter is D4 Healy, Plat A, Lot 2, 129 Boston Neck Road.
Evening, Mr. Chairman.
Evening, Mr. McGreen.
Jack McGreen for the applicant. The office is located at 21 Garden City Drive, Cranston, Rhode Island. The applicant and owner is Joseph Healy. The property is located at 129 Boston Neck Road. It's located 2 lots up from the Dunes Club and in fronts on Narragansett Beach, and is located in an R80 zone with approximately 69,920 square feet. This matter is before this board because the property storage shed is located within a coastal relay overlay district and therefore requires a special use permit pursuant to section 4.4 of the zoning ordinance. And of course, it's along with 194 feet of dimension relief from the setback requirements of section 4.4, because this property is within 6 feet of the coastal feature, which is actually the wall. If you go back to that previous photograph, that wall is the coastal feature right there. And the shed is in the lower left-hand corner, and that is 6 feet from the wall. Since the reconstructed shed, and by the way, this was built, and you'll see it in the packet, it was reconstructed without pulling a building permit or coming before this board. Obviously, they didn't get before this board because they didn't pull a building permit, so that's why we're here. But that being said, since the reconstructed shed doesn't comply with the FEMA standards, we will need to seek relief from the State Building Standards Committee, in addition to applying for the CRMC permit. So that is going to be a battle for another day, but right here, we're just looking for the special use permit and the dimension relief. I do have Molly Titus here from Deprete Engineering to address the development standards contained in section 4.4. So I'd ask her to come up here, be sworn in. And I know she's testified here before, but go ahead.
Molly Titus from Deprete Engineering. Welcome.
I know Molly's testified here before.
We'll recognize her as an expert for purposes of this hearing.
Thank you very much. Molly, have you had an opportunity to review the development standards contained in section 4.4?
Yes, I have.
And would you go through those 7 standards for the board?
Absolutely. So under 4.4, section C are the development standards for within the Coastal Resources Overlay District. Condition or standard 1 is that the project will not interfere with public access or use and enjoyment of tidal waters. This standard is maintained. There was a building located in the same location. It's up on top of the seawall, which the town beach traffic is beneath this wall, not across this property. Standard 2, the proposed project will not degrade the aesthetic or recreational values of tidal waters. This building wasn't built any closer to the coastal feature than the existing building. It was replacing the existing footprint, so no degradation of aesthetics or recreational values of tidal waters would take place. And I would argue probably that this structure is nicer looking than the previous one. Item 3, the proposed project will not degrade existing water quality or adversely affect circulation and flushing of patterns of tidal waters. Again, no additional impervious area was created with this. Existing footprint was maintained from the previous structure. Condition 4, proposed project will not increase volume or velocity of stormwater. Again, by nature of its matching of existing impervious area, this standard is met. The proposed project will not diminish the value of any shoreline feature as a storm or hurricane barrier. Again, its location on top of the existing seawall that demarcates the property from the beach would meet this criteria. Condition 6, any filling, grading, excavating, or other land alteration will be minimum necessary to construct the proposed project. This is true. No grading was done. The existing foundation was actually maintained, and the new walls of the shed were constructed on it. And then condition 7, the proposed project will not pose a threat to public health, public safety, or property. This is on private property. No impedance of public access has been taken place, and I would say a new structure would be more in the interest of public health in terms of degradation or its demise.
Does the board have any questions for Molly? Otherwise, I'll just...
I have a question. I was under the impression that the former shed was smaller than what is there today.
The former shed walls were, but there was a concrete pad out in front of it, and the entire footprint of that was used for the shed that's there now. So the existing impervious area is the same.
So there was like a little patio in front of it?
There was, yeah. If you look at the screen, the arrow on the right-hand side, there's a green, very faint dashed line. And then it says location of previously demolished concrete pad. That is an error. The original design for the shed had a new foundation. The existing foundation and slab was remained, so the concrete slab was in front of the structure and then under the structure, and that's what was built upon.
So let me just get this straight. There was an old shed that was on a slab.
Yes, with a big pad out in front of it. That was concrete.
So they took the old shed off and they built this new one to fit the pad.
Correct.
When was the pad installed?
60s? This is a question. This is a question mark with the 60s. It is the same or predates the house.
Yeah, it's been there. It's been there, that old shed was there since I've been living in Narragansett, as far as I know. Just, it's been there a while. I've been coming down here for 68 years. It's been there a while.
Okay, that answers my question. Thank you.
Any other questions for Molly?
I don't know if this is for Molly, but can someone just confirm the timing for me? It looks like this was 2021?
Yeah, was it 2021?
Yeah, this has been going on for some time. So what happened is, we got a complaint about the construction. We issued a notice of violation to cease work. We had some difficulties getting communication with the contractor to move forward in getting this permitted, number one. Then there was a change of contractors through the project. Mr. Healy also had some various different representation for him, as he was out of town a lot, to deal with the issues that we had. So it has been ongoing for some time. We've been trying to get this resolved since that time. Unfortunately, a lot of time has passed.
Was the stop work order issued before the work was complete, but then by the time?
It was prior to that being completed, and then they completed it. Besides that point, we didn't have any access. The property's all gated, so we had very limited access unless we were granted permission. And so the structure was completed prior to, beyond the status of when we issued the stop work.
And you think it's the same issue for the CRMC cease and desist order as well?
The same issue with what?
Well, there's also a cease and desist order.
Yes, they were notified. They got a copy of my notice of violation when that was issued, and they then subsequently issued one themselves because it is in their jurisdiction, and they didn't have any type of assent.
Okay. And then, so why now? Like, how is this coming back up?
Well, they still got to resolve all of the issues that it's in violation of. Number one, there are building code issues that they're in violation. They don't have a CRMC assent. So those issues are what's driving this to be, resolved once and for all, one way or another.
Sorry, and what's making you come here? Like, are you?
Well,
are you charging them fines, is that, or?
No, he's seeking a special use permit
Okay,
to
okay.
keep the
try-
existing structure within the coastal setback.
Okay,
Yeah, had my client applied for a building permit, he would have been denied. He would have listed the special use permit and the dimension of relief, the 196 feet, and then we would have come here, and we would have gone through this process that we're going through right now.
And so I think the only issue before us is whether or not we will grant a variance and special use permit from the coastal overlay district.
Correct.
Which is 200 feet.
Correct. And then the town is further going to go forward to the Building Code Standards Committee, where they'll be seeking a variance from building code standards relative to FEMA regulations, and then after that, with CRMC applying for an assent. So there's still a few more steps that need to be taken.
So with regards to FEMA, it speaks about a requirement for the structure to be elevated?
Structures in the VE zone are required to be built on piers. This being a shed is handled a little bit differently than a regular residential dwelling or commercial structure. I couldn't find anything in their regulations that required sheds to be elevated similar to the way a house is, because it's used for storage. And in fact, in a VE zone, storage is allowed below the flood zone in a VE zone as long as it's limited to storage. So this structure would qualify for that. So I don't believe it would need to be elevated. They are will be putting in flood vents, which would be required as part of being in the VE zone, so that will be addressed. But other than that, I found nothing that required sheds to be elevated. As you can imagine, if somebody wanted to put a shed in their yard and they have to elevate it 10 feet, I mean, it kind of defeats the purpose of, I don't know how you would get a lawnmower out of there, but, so that's why they're kind of handled a little bit differently than a regular residential dwelling.
So I'd like to briefly run through the 12.5.
Question from Mr. Ball.
I just have a question. So it says that the whole structure was demolished?
Yes.
And that the staff couldn't determine what portion of the foundation had been retained? Does the fact that it was demolished then in its entirety, but it's being considered now, does the uncertainty around
the Wesley case?
regulation?
Wesley case, yeah.
Yeah, John,
factor
I can address that. The way my office has handled demolitions, voluntary demolitions, that if any portion of the structure remains, that it's not considered to be a total voluntary demolition. In this case, the foundation did remain, therefore it was not considered to be a total voluntary demolition, which would have triggered setback issues and other issues. So because they retained the foundation, it was not viewed as a total demolition.
Okay, good. Thanks.
And I'm just going to briefly run through the standards to be met under section 12.5, but just for the record, I will point out whether or not I consider these standards to be objective or subjective, because as you may know or may not know, RIGL 452412 states that if a town is going to have a special use permit, those standards have to be objective standards. And as I go through these, some of these, in my opinion, are subjective and probably shouldn't be in the ordinance. I'm not here to make new law. I just thought I'd throw that out there to get it on the record. The first standard is that the special use is specifically authorized by this ordinance and setting forth the exact subsection of the ordinance. Well, it's a use, it's an accessory use, and an accessory use like a shed is permitted in section 7.3. So that standard is satisfied. The next one, the special use complies with the performance standards set forth in section 4. Molly just testified on that requirement. The next one is that it will not substantially or permanently injure the appropriate use of surrounding property. Improving the appearance and structure soundness of storage shed, like Molly testified, will not injure the use of the surrounding property. That the granting of the special use permit will not, oh, by the way, so I said I was going to identify let me just go back for a second, I didn't identify them. Number one is objective, obviously, it's a statute. is it permitted or not? Performance standards, I think they're all objective, the ones that Molly went through. The next one, not substantially or permanently injure the appropriate use of surrounding property. I think that borderlines on being subjective, more subjective than objective. The next one, I believe is subjective, that the granting of the special use permit will not alter the general character of the surrounding area or impair the intent or purpose of this ordinance or comprehensive plan of the town of Narragansett. Storage sheds, they're very common in town, throughout the entire town. This shed's design matches the existing home, and certainly the quality of the shed construction fits in with the construction of the waterfront homes, at least the home that butts it to the right. I think you can, if you go back to that first picture, just to show that it fits in, I did a printout. I can submit this as applicants. Number one. It has accessory, they're beautiful accessory structures. You know, it looks like he has a pool shed over there and a fancy shed. And this shed, we don't have a picture of the house, but that shed basically kind of matches the design of the house. So it's not your typical shed like I have on my house where I keep my garbage cans. It's a nice shed. The next one, number 5, that the granting of the special use permit will substantially serve public convenience and welfare. I don't think anybody on this board is going to argue that is pretty subjective. Again, I'm not here to make law, but I would say that improving the architectural quality and the aesthetic look of a building always serves the public interest. The next one, I think it's a combination of subjective and objective, that the use will not result or create conditions inimical to public health, safety, morals, and general welfare. I circle morals and general welfare. I think that's pretty subjective. That being said, I did submit a engineer's 128 certificate. I don't know if that was in your packet. If not, I have a copy of that along with a letter from Carrigan, which certifies that it will comply with all of the building requirements in addition to any requirements that may be set by the State Building Code Standards Committee that we have to go before. And should we be successful in obtaining that relief, we'll certainly comply with all those standards so as not to create a condition that would affect the safety or the public health of the community. Just moving on to the dimensional relief, because we need 196 feet of dimensional relief. The first standard would be I think the staff report referenced the old standards, so I'm going with the new standards. That's what was in effect at the time I filed my application. That being said, the oceanfront location of the storage shed has been in existence prior to the restrictions imposed by Section 4.4, and the location of the reconstructed shed remains in the same footprint as existing shed. Those facts, that's what makes this relief request due to the unique location of the structure. That's where it's been. That the hardship is not the result of any prior action of the applicant. I know you're thinking, oh, they're looking for relief. We're not suggesting, or the applicant's not suggesting, that we have a hardship because of reconstructing the shed without a permit. That's not the hardship. The hardship is that the shed is located in an area that is no longer permitted, and that was not the result of any prior action of my client. We're not looking for relief based on the hardship of putting the shed up without a permit. That the granting of the request variance will not alter the general character of the surrounding area. This reconstructed shed has always been a part of the surrounding area, and therefore is in keeping with the general character of the area. It's been there forever, so nothing's changing other than making it look nicer. And then not impair the intent or purpose of the comprehensive plan. If you look at a portion of policy LU 2.2, which is referenced in the staff report, of the comprehensive plan, which policies to reinforce community character. The shed has been in existence for some time. The reconstruction of the shed reinforces the character of a beautiful home that fronts on Narragansett Beach that, quite frankly, is visible to the public. The shed was in need of repair, and its reconstruction and architectural improvement reinforces the character of the home, and that has existed in the community for some time. That being said, that completes my presentation, but I'd be more than happy to answer any questions.
Doc, are there any pictures of what was there before?
I think I may have one picture. Give me 1 second.
Is it something you can give us that we can mark as an exhibit? Or? I think it might be helpful for us just to see what was there, because I know people have questions about the pad and.
Want this as Exhibit 2?
Anyone have any questions? Mr. McGreen, before you?
I don't know, maybe anybody can chime in here, because, I mean, I'm having trouble with the temporal, how to do this. When, we have to look at the hardship that the applicant is seeking relief from in a bunch of cases. At what point in time are we talking, where is the hardship? I mean, is it now? Is it when they should have, when they started building? Like, what do we? Variant, right.
Yeah, my last 3 comments related to the dimension relief permit, and that relates to the 196 feet of relief we need. And quite frankly, if we had to comply with the 200 feet, I think we'd be in the Dunes Club parking lot putting the shed over there, which wouldn't be permitted. So it's been there forever, just like the town's beach club has been there forever. That wouldn't be permitted today under today's standards. But and anything on the water within 200 feet wouldn't be permitted. But so it was existing. It's existing now. And the only thing that's changed is it's a new building.
And the hardship is that if we say no, like, what would happen if we declined, if we denied this
Well,
request?
I think I've met the burden of the hardship. You know, I think I've met the standards. I mean, we went through the specific standards, and then there's the dimensional standards. And, you know, we didn't create the hardship. The shed's always been there. We need the relief. It wasn't self-created hardship. That's where the shed was. That's what, you know, so.
And the hardship is they don't have any other place to store their stuff. This was always there. They used it as.
I'm sorry,
I mean, the hardship is there's no other place for the shed to be located.
Right, where,
This is
yeah, if you said we
absolutely
need
the
to
only
comply.
place on the property that they could have located the shed.
Yeah.
Like, I'm trying to think, if they had come when they were supposed to and asked for relief, what's the hardship? The shed, they were going to be demolishing the shed anyway, so could they have relocated it at that point?
I suppose they could have relocated the shed, but, well, I don't know if they could. I don't know if they could. I mean, then they'd have to do another foundation in another location, and the whole purpose of keeping that foundation is if you completely do that, then you would have to meet all the standards, which we don't have to because that shed is already there. And we're not going any closer to the coastal feature. And like I said, it's been there, so we just recreated what was there. We put a new shed in the same place, so it wasn't a self-created hardship. And like I said, the next-door neighbor has a shed on their property. And everybody, including the town, is within the coastal feature. So we're not doing anything that everybody else on the beach isn't doing.
Does that make it right?
It's not a question of right or wrong, is that the rules, that's what the rules were. There were no rules 60 or 70 years ago. And it's really not a question of right or wrong, it's a question of whether or not we can meet the standards. the objective standards.
So this looks, it appears to be a lot bigger. So I
It is bigger.
understand the pad.
It
And
is
it's supposed
bigger.
to be the least relief necessary as part of the
No,
criteria.
I don't believe that's standard.
Not anymore.
General Assembly in 23 or 24 removed that criteria. So the last element there, least relief necessary, is no longer required. So you can disregard that.
Oh, sorry, it's in the packet.
It's in the packet,
I know,
yeah.
that's why I made a note to jump in.
Anything else in here that is not
When we go
relevant?
through the standards, if there's an issue, I'll be sure to let you know.
Because I'm going through what's in the packet, so it's hard
Yeah,
for me to keep up with what they're, because they're reading off
I
of
don't know if
something
you have your
different.
zoning ordinance in front of you. My guidance would be to look to 4.4, which are the development standards that the expert witness went through, as well as 12.5 as related to our special use permit. For the variance, that's also in our zoning ordinance, and it's in state law.
I think in defense to the staff, I think they took the position that the standards should be applied at the time we did the work without a permit. And that's their position, and they're welcome to have that position. But my position is, and I think I have the correct position, is that the standards to be applied are the standards in effect, not at the time the illegal work was done. The standards that are in effect is the time you applied for the application, which was a few months ago.
Any other questions?
So that's why it's in here. I'm kind of confused. So
Yes, I-
in the beginning of the packet, it says that we're going off of before, like, older statutes, and now are you disagreeing with that? Because at the beginning, it says,
No, I just want to make, okay. So, yes, Ms. Rochot, yes. So past practice has been when the state has made changes, sometimes the town has, for lack of a better description, acknowledged that the building permit application came in prior to a change, and then the applicant would have the choice of whether or not they wanted to go with the old regulations or the new regulations. For those of you who've been around for a little while, that happened in between 2023 and 2024. We had a lot of applications in the pipeline, and the state changed a lot of, they made a lot of changes to the zoning ordinance, and applicants had the opportunity. The staff, my department, we acknowledged that this building permit came in 2021, and we applied the 2021 rules. Mr. Pimentel has just informed you that it seems like it should go under the newer rules. So that's why you have the old ones, because we used the date of the building permit, which was 2021.
got it, okay.
I want to comment on that. I'm reading the decision that you provided us with in the case of Strutt Jr. versus Town. And the judge there in the decision on page 5 says, "The established policy of Rhode Island jurisprudence is to, quote, apply the law in effect at the time when the applicant builder submitted its applications for a permit to zoning board." And then he cites 3 or 4 cases. That's something we're going to be discussing later on, I think.
Yeah, and that's what I said, so the application, it's at the time of the application submitted. So,
Yeah.
Is that the Twin
my
Willows
point
case
is,
you're talking
I don't
about?
think it's discretionary.
The Twin Willows case? Is that the Twin Willows case? Is that- Yeah.
That's the Twin Willows case,
Yeah.
yes.
Yep.
So I guess that was my response to your discretion on which to apply.
Well, Judge Lanfair is making new law every week.
It's what we have.
Keeps us employed.
Okay, so we're going off of current law. Is that what that's what you're saying, off of that case law?
Well, what's the date of the application here?
I can give my date of my
The
application.
before
Um,
the zoning board, which would make it 2021. Not the building permit. It says
My denial was October 1st,
Um,
and then
I'm-
I applied sometime after that.
And November 4th, 2025 is the date of the application.
I might have the,
November
Yeah.
4th, 2025 is the date of the application.
Right.
I usually get a receipt from Heidi and throw it in the file. I'm looking for that. Hold on.
If I may,
The building permit was issued in, well, it began in 2021. I have the building permit number, it's B21, which indicates.
Now, we're looking for the application, when I filed my application.
Mhm.
Look at the language in the decision, you can tell me if I'm misreading.
Donna, here's my receipt. I received the receipt on 11/16/25 from Heidi. There you go.
That's when you filed this application.
Yes.
Not the application for the building.
Right. You know, the application for relief was filed on 11/16/25.
All right,
I'm,
go ahead.
I think I'm really confused, I'm sorry. So the building permit, there was a building permit applied for back in '21.
No, there was not. That's,
Okay.
yes, there was not a building permit applied for.
So when was the date of the building permit?
There is no building permit.
Okay, so that's,
Between the date of applying for a permit, which is done in Wayne's office through the portal, the date of the application to go to the zoning board was filed November, or whatever you want to say.
but I may have misheard Amanda saying that the building permit was applied for in 2021.
That's what the complaint was filed.
Okay, but that's not the building permit. Okay, okay. So the fact that, so they didn't apply for a building permit the way that the law requires. So they're able to use the newer law, which is more advantageous to them because they just applied for a building permit? Is that how that works?
It's when, as our member mentioned, it's when you apply. They applied in
For the variance, okay.
2025. That's when they're, because certain rights can vest. Laws can change, as your ordinance is changing in front of the council. You need a vesting period where you're vested in the law. That's the 2025.
But you do see my,
Oh,
you see my issue. I mean, it was, if they had applied for the variance and the special use permit when, way back when they were supposed to, they would have been under the old law, which would have had least relief necessary, would have had all of that other stuff that we, you know, that makes it a little harder to get a variance. And,
They'd have to have a lot of foresight to have waited 4 years to.
no, I know. That's why I'm saying, what do we apply? What do you, like, what do you apply? But. A boat. To the zoning board. Okay. I don't know. I don't know what the answer is.
The answer is we're going to apply the law that applies now. Think.
So Nick, you
All right.
said that in the current book that we have, we should be looking basically at sections 11 and 12, is what you just cited. Okay.
Do you have anything else, Mr. McGreen?
I do not, Mr. Chairman.
All right.
Thank you.
Are there any people, any proponents of this application in the audience? Hearing none, are there any opponents? Oh, okay, so, all right. Oh, okay, I'm sure they are. Someone make a motion to close this hearing.
Could I just ask one more question before we do that?
Sure.
Why didn't they apply for a permit? Didn't ask the question?
I did not ask the question.
Just curious. Thank you.
Can I have a motion to close this hearing?
I'll make a motion to close the hearing.
Second.
All in favor?
Aye.
Aye. Is there a motion, or do you want to hold this for a written decision?
I think I'd like some more time. I don't know about anybody else, but just to review it.
Anyone have any thoughts on that?
So, Mr. Chairman, if you close the hearing, the law says, and I printed it out for conversation earlier tonight, the law says you have 15 days to make a decision. So unless you're going to get some acquiescence from the applicant, or you don't close the hearing, you have 15 days.
that case, we can either ask Mr. McGreen for his acquiescence for, is it 15 days, or can we get him to waive the 15 daes so that we have an opportunity
It's just
to?
following a public hearing, so you might want to reopen the public hearing. I'm sure Mr. McGreen doesn't have a problem with that.
I mean, the good news is the shed's already up, so the time really isn't a factor for my,
That's
and it's
what
the
I-
winter,
that's
so
why
he's
I'm
not using
suggesting
the
we
store-
rent something.
So-
All right, how about if we make a motion to reopen the public hearing so that we can ask Mr. McGreen if we can waive this time constraint so that the board can issue a written decision. Is there a motion?
I'll make a motion to reopen the public hearing.
Is there a second?
Second.
All in favor? All right.
And the applicant has no problem with waiving the 15-day timeframe.
Well, there would-
Or you could leave it open, Mr.
Well, we
Chairman.
could just leave, we'll
You
just
could
leave it
leave it
open
open.
and issue a decision at the next
Correct.
meeting, which would be, yeah, so we're really piling on for February 19th. but
2/19?
Does that sound good?
So, Mr. Chairman, Mr. McGreen has acknowledged already that time is not of the essence for his applicant. Would he be willing to move to March, since we now have,
I'm going to be on March anyway, so that would be fine with me as well.
All right.
if that would be, because you've got a big bottleneck right now in
All right,
February.
why don't, can we make a motion
Yeah.
to continue this for a decision on March 19th? Is there a motion?
Make a motion to move this to March 19th.
Is there a second? Someone going to second that? Second. Thank you, Dave. All in favor? Aye. Aye. March 19th.
Yeah.
Okay, I think we should do that because it's very convoluted. All right, the next matter on the agenda is O'Neill, Tax Assessor's Plat D, Lot 230, 112 Caswell Street.
Evening, Mr. Chairman.
Evening, Mr. McGreen.
Jack McGreen from Taft McSally for the applicant, 21 Garden City Drive, Cranston, Rhode Island. The applicant and owner is Tony O'Neill, who's here tonight. Property's located at 112 Caswell Street and is identified as Lot 230 on Assessors Plat D. The lot's located in an R10 zone and it has a lot area of 12,535 square feet. The proposed improvements consist of the removal of an existing front steps and wooden walkway on the property and replace it with an open 8-foot by 30.5-foot covered porch. The existing steps are already within the front yard setback by about 3 feet. Application is seeking an additional 5.5 feet for a total of 8.5 feet of relief from the front yard setback, and in order to construct a roof entry and front porch, and there's a picture up there, for the protection of the weather in front of the front door, and for the aesthetic look, and for a place to sit in the summer. That's the reason. I do have a picture I'd like to enter is applicant's number 1, and it's just a picture. It's just a picture showing the sideline. The reason why I brought that picture to your attention is because I just wanted to show you that bringing the porch out will not cause any view corridor issues with the corner of the lot. You can see that the trees are trimmed back, so from that angle, the picture, you didn't really have it in this report, but that picture shows to the right how it's pretty open, so bringing out that porch a few feet isn't going to interfere with people driving by as they approach the corner to take a left or a right. Okay, also, I have another set of pictures, just to above this plaintiff's applicant's number 2. Applicant's number 2, and if you look, those pictures are all houses located on Caswell Street, and I think everybody on Caswell Street has a front porch. You'll see that one, and they probably look like they're closer to the front yard than is allowed today. And the point of that is that, in my opinion, it won't alter the general character of the surrounding area. The house was built in 1930, that's what it said on the tax assessor records, prior to the setback requirements of the zoning ordinance, and the setback relief is due to the unique character of the structure being legal but non-conforming. The picture I provided seems to indicate that many of the other houses have porches at Caswell Street, and like I said, it looks like they're all within the current setback. And just finally, I'd argue that, getting rained on, not having a front porch to sit on in the summer is more than a mere inconvenience under the requirements of the statute, and if the relief is not sought, the relief sought is minimal to the reasonable enjoyment of the permitted use of the property, given the general characteristics of the surrounding area. I did actually happen to do a calculation because of that first reading before the town council, and if the front yard setbacks were going back to 25 feet and we were to ask for a 15% modification, tonight we would only be looking for 1.6 inches, I think. So, not that that's relevant, I thought that was interesting that if we waited probably another couple of weeks, we probably would have just shrunk the porch by 1.5 feet and just look for a modification. But that being said, I do have the applicant here, and I also have the builder, Mr. Virgilio, if you have any questions for him. But I'd just like the applicant to come up and just state briefly why she wants the porch.
I do. Please state your name and spell your last. Tony O'Neill, O-N-E-I-L.
Tony, will you just tell the board briefly, the purpose of the front porch and how you intend to use it?
Who doesn't want to just sit on their porch in the summer and watch the world go by? That's all I want.
Anyone have any questions for the applicant?
And I think it'll make the house look nicer, to be honest with you.
Any questions? Thank you.
And I'm not going to call Mr. Virgilio up unless you had any building questions, but that being said, that completes my presentation.
Anyone have any building questions? None. Thank you, Mr. McGreen.
Thank you, Mr. Chairman.
Take it from the vacant hall here. There's no proponents or opponents. I have a motion to close this hearing.
So moved.
Is there a second?
Second.
All in favor?
Aye.
All right. Is there a motion?
Mr. Chairman, with regard to Project Summary O'Neill, Tax Assessor's Plat D, Lot 230, located at 112 Caswell Street in the pier section of Narragansett. I note that the lot is also located in the Central Street Historic District, and any relief granted by this board will be subject to approval of the Historic District Commission. The applicant is requesting relief from the dimensional regulations, specifically section 6.4 for, the relief is for, I'm not sure how to state this, an additional 5.5 feet from the front yard setbacks to build a covered front porch at the property. So I'm going to make a motion that the board accept the following findings of fact, as the findings of fact as set forth in the project summary, including facts A through E set forth therein. In addition, I'd like to incorporate all of the other information, including some of the plans and some of the pictures that were presented here today as evidence. As representative from the applicant, Mr. McGreen testified that the standards to be met in granting, the standards for granting the relief that's being requested have been met. He testified that that the hardship, which has been reported to be, want to be able to enjoy their property fully. They can't enjoy it the way they want to right now. It would increase the aesthetic of the property, and it makes the property, nicer to look at as well as the neighborhood. I didn't hear any testimony about the unique characteristics of the subject land, but I think it seems to me part of the other discussion on not against the character of the neighborhood, that all the lots seem to be, not necessarily small, but a lot of the houses are close and impinge on the setback anyway. And the rest of a lot of properties in the neighborhood do have front porches that go into the front yard setback. So it wouldn't, there is that testimony, it would satisfy the standard that it doesn't alter the general character of the surrounding area or impair the intent or purpose of the zoning ordinance. I did not hear any testimony about whether or not the hardship is due to the physical or economic disability of the applicant, so we're going to assume for purposes of this, that it's not due to any disability of the applicant. So with that being said, other facts. The planning board found that the project was in conformance with the land use component of the comp plan, and they recommended the project for approval to the zoning board. In addition to the conditions that staff has in the project summary, they asked to have another condition added, and that would be that the front porch not be enclosed in any manner, so that the view that Mr. McGreen was showing us in that picture was not obstructed in any way. They asked for that to be a condition of the approval, and I add that to the conditions that I'm going to recommend. So those are my findings of fact, and I submit them to the board for approval.
Is there any discussion? No discussion? Is there a motion to accept the findings of fact?
I'll make a motion to accept the findings of fact.
Is there a second?
I'll second it. I'm sorry, Mr. Chairman, I thought that was Ellen's motion. Are you seconding it?
Yes.
Yeah, because I did,
Sorry.
that is, yeah.
Okay.
Yep.
I'll second it. Thank you.
All right, what's the board's pleasure?
All in favor? We did the all in favor on the motion? Okay.
On the motion, yeah, everyone, I think everyone had said aye,
Okay.
right?
Aye.
On the
Okay.
findings of fact.
On the findings of fact. Okay.
Yes. Wait a
Mr.
minute, hold on a second. We missed something?
Mr. Chairman, you didn't take a vote, you just had Christine second it, or Ms. Brochu second it.
All in favor?
All right, let's try that again to make sure we got it.
I
Is
made
there
the
a
motion.
to
I made the
accept the
motion to-
findings of fact?
Right.
I second it.
Okay, all in favor?
Aye.
Got it? Okay, what's the
Got it.
board's pleasure?
Mr. Chairman, I make a motion that the board approve the relief requested, subject to conditions 1 through 5 as set forth in the project summary, with the additional condition that the porch itself remain open and is not enclosed, so to not limit the view, whatever they call that, when cars are turning and walking.
And the,
Oh, right, and that this, our approval would have to be conditioned upon approval of the Historic District Commission as well.
okay, is there a second? All in favor?
Aye.
Aye. Thanks, Jack. Very good. All right, I don't think we're done yet, though. We've got, I think the final matter is reports from staff, the solicitor, and the board regarding the Superior Court decision and some legislative updates. So I don't know who's handling that, Nick or... So you can figure out why we screwed up on the math in that decision, because I need a good explanation of that, because I don't even remember that.
I'll defer to your summary. It relates to nonconformities and the certain development standards that have to be adhered to. There are some good nuggets in there from Judge Lanfear to provide us guidance, and I know at least one of our members was paying attention to those. But we have a sophisticated board. The decision's pretty straightforward, speaks for itself. It was a math equation. We applied math, square footage from the wrong time. It was supposed to be applied from 1989. That was one of the development standards, and the square footage applied at the hearing was from more recent, much more recently. Am I missing something?
So we did I
We
think.
have to
that-
look at the square footage from 1989.
Yes, which we did, and I think there's a question of whether or not Judge Lanfear used only the building footprint and not the building and deck footprint, which is historically what the town of Narragansett has done, previous solicitor and current solicitor. He's here if you want to ask him, and he can correct me if I'm wrong. So there's that, but is the bigger overarching issue the fact that you can't vary from the standard of a special use permit?
He doesn't seem to give you much wiggle room. It's if you don't meet the development standard, then you have an issue. There isn't, in the decision, it doesn't speak to certain exceptions there, so we'll use that as guidance going forward.
So in circumstances like this, if they come up before us, are we going to rely on staff to do the mathematical calculations for us? Because we're only going to be able to rely on what we get in the staff report, I think, right?
Okay, so one of the interesting things about the decision, and I'm not legal, so Dick can tell you if I'm incorrect here, but one of the things that Judge Lanfear said was that the applicant should actually be providing the information and not the staff doing the work. So that will be easier, frankly, for staff.
I think the language used was the burden is on the applicant.
Yes.
They're convincing you. Your staff.
Yeah, no, it's
So
excellent.
I rely on them. I don't think you should not rely on them.
So we're just going to, now in the future, we're just going to leave it up to the applicant to bear the burden of proof on those points if this ever
Let them
comes up.
carry their burden, but I would also want staff to double check that, because I wouldn't want any
Yeah,
misrepresentation.
I guess
being
that's
put
what I
in
meant
front
to
of them.
say. So that,
It's too bad because that place is uninhabitable in the winter to eat. When they open those doors, it is frigid. Kind of got to like shut it down for the winter and come back in the spring and summer.
are there any legislative updates? That's on the agenda, that's the only reason I'm bringing it up. Otherwise, we can all go home.
Sure, so just to give you some heads up is what the planning board's been doing, as you, I'm sure if you're watching town council or the planning board meetings, before the planning board in the last 2 or 3 months and moving on to the next couple of months. On Tuesday, there was a public hearing on the reversal of 99.9% of the 15% dimensional regulation modifications, which took place in 2024. And the first reading occurred, so, barring any changes that happen at the second reading, that will take effect at the next, presumably at the next public hearing when they put it on for second reading. There is an ordinance draft right now in front of the planning board for a change to the student-occupied dwellings. And it mimics the same language as households, which, for anyone who's interested, it changes the number of students allowed from 3 to 5, which mimics, and one student per bedroom, which mimics, is similar to the state law for households. There's also, Mr. McGreen may have mentioned it, I don't recall if he did. Mr. McGreen put an application out to update Section 9, which is nonconforming uses and structures, to address the Supreme Court decision. And we are winding our way through that right now at the planning board to try to get a language that meets the needs of, let me rephrase, is legally defendable. So we do have, Mr. McGreen is working with the planning board on that. Ryan has been taking on the lion's share of the 2025 changes that took place at the last legislative session, which we've been a little bit slow and go because it took a while to get some feedback on, and some drafting on what actually applies to the town of Narragansett and what doesn't, what is regulatory and what is discretionary. So we did present that to the planning board yesterday, and we are intending to have a draft of that to the planning board maybe next month, or certainly the month after. And the legislative session opened for 2026, so we'll wait and see what happens.
So what is I mean, there's a lot of going on with, do we have to comply with state law? Don't we have to comply with state law? You know,
Well, we have to
specifically-
comply with state law.
No, I mean, I guess what I'm saying is, can we, this is what's going on in the community. I know the answer, because I research this all the time, and I know exactly what the answer is here, but in my mind, I know. But, like, for example, the 5-student versus 3-student ordinance. Everyone is saying, you know, some of the community are saying, home rule charter supersedes state law, we should be able to govern and do what we want with respect to our zoning, and we should be able to put a 3-student limit on our rentals. State law just, you know, in 25, like you just reported, I mean, the Zoning Enabling Act of the state of Rhode Island changes that to 5. So we can't be, even though, I mean, home rule is home rule, but we can't be more restrictive than 5. Is that what the position the town is taking? I'm curious, because I've heard it both ways. I've heard,
It's quite a ball of wax, and it's not just statute. There's a number of cases, including the proverbial Providence case that dealt with this.
Right.
So the town's working through it. I know there's a lot of opinions on both sides. I don't necessarily want to get into it all. We can talk off the record.
Right. Okay.
But I know the town's working through it.
okay.
So there's a lot of demolition people that were.
I just want to, I don't mean to sidestep you. There's also pending litigation involving the town. That's why I'm a little cautious with it. I don't want to say one thing here and have to say another thing in another venue, so I'll just leave it at that.
I mean, I just think it's a preemption issue. You know, does state law preempt? And it probably does.
So
Anything else?
a lot of the bottleneck happened because we kept pushing off demolition, and we're going to be hearing some of those? And did something change?
Or where
Well,
it's
that's what Mr.
non-conforming
McGreen's doing.
uses or non-conforming structures being demolished, right? I mean, you could still demolish a conforming structure and rebuild it, right? If you wanted to.
That's what's being addressed by, it was addressed by Mr. McGreen last night. It will hopefully very soon be going back to the council for codification as an ordinance.
So we have a meeting next week. Are some of those?
I don't think it'll be that soon.
No, I mean, are we hearing any of those?
No, the only one you're hearing right now next week is the motion to dismiss. That's the only one that got continued to next week. We had originally thought, you had a lot of continuances for other matters this evening, not the Supreme Court decision. That when we originally put the agenda together, we thought you were going to be hearing everything. So we asked for a special meeting, just to do a roll call for a special meeting. And, well, you had a lot of things, 4 or 5, how many things fell off the agenda? 4 or 5, something like that. So there wasn't really a need for that, except it sounds like you want to do the motion to dismiss next week. So that is the only thing on your agenda next week.
So just that one matter?
That's it.
Yeah, good.
When will we be getting the packets for that? What
I don't
are
think
we hearing next week?
All we're hearing is that motion.
No, it's just the motion to dismiss for the Tevereau Glance appeal,
So
which
we
was the
should be
first
getting
one you
a
heard
formal
tonight.
Objection from Mr. Mancini. Yeah,
Yeah.
right.
So that's the only thing that we're hearing on.
That's the only thing you're going to hear, because you moved it to the 28th. Yeah.
I mean, I thought we had other things
thought we
on
had
that
other
day.
things
That's
on
why
No,
I
well,
did
no,
that.
you would have had to move tonight if all of your applications had been heard. So Mr. McGreen had a couple that he needed to pull off for other reasons, but you had You had at least a couple. I can't recall them now.
I understand.
Yeah.
So you were leaving that open to say, hey, let's push these off.
Yes, so,
Needed that
so we
buffer.
weren't here in case it's only 9:10 now, but there was quite a possibility, if you heard everything tonight, that you could have been here until 11 or 12 o'clock.
Thank you.
It'll be a short week next week, short night, maybe.
All right, do I have a motion to close?
Mr. Chairman, before we
Yes,
close,
yes, sir.
it's not on the agenda, however, it is a report from staff. I don't recall if I had mentioned it previous, but in April of 2024, or of 2025, the town applied for a grant through the state, Rhode Island Division of Statewide Planning, to go through the town's current zoning ordinance and review it and look for ways that we can promote resilient building in regards to climate change, sea level rise, and so on and so forth. And given that we have a project, we have a partners project group which consists of additional town staff and liaisons from different boards and commissions. And our consultant has asked us to consider the zoning board as well. So I would defer to the board to potentially appoint a liaison that will sit on the project partners group that will attend 3 meetings over a 1.5-year span, whether they be virtual or in person, that's yet to be decided. They will also be asked to partake in I'll call it an intake or an onboarding interview with the consultant via Zoom that will try and understand how this board will potentially have input. And then that liaison will bring the information back to the board and report back to what we're working on and the findings that come from that initiative.
Okay. Do you want us to decide on that tonight?
Yes, please.
Is there someone?
Volunteers.
Is there someone willing to volunteer for that? Looks like John wants to do it.
No, is this something that needed to be for a vote on the agenda for open meetings law purposes?
If you have, I don't think it's a formal.
It's not a recommendation, okay. All right.
There's a lot of silence right now.
Who's
It's
interested in
resiliency. I'd do it if no one else wants to do it.
To do it, but my appointment is only through the end of June, and if I don't get reappointed, then, so with that caveat, I'm happy to take, it's only 3 meetings over a 1.5 years, I can do that.
Can an alternate do it?
I think it's going to be, it doesn't make sense.
So if, I would say that if you couldn't, if for whatever reason you couldn't remain as the project partner then this board would appoint someone else, or have someone be voluntold.
Voluntold.
I'd be happy to help you
But it doesn't.
if anything comes up.
No, it's,
No, it's, if you're into resiliency and conservation, then, by all means.
It's interesting that you say that, because when I was on the HDC, that was one of the points that I raised when Mike was there with us, saying, we're dealing with historic standards, and how do we deal with our changing climate, and we were talking about it in the context of solar panels and other walls and other resiliency elements, so that's why I'm volunteering, because I actually raised it there.
Yeah, and if you have any conflicts, tag me in.
Okay?
Now, the request is not necessarily to have a zoning board member there, just somebody that zoning recommends. So, I mean, is the membership on the zoning board a prerequisite? Because then she could even stay, if she doesn't, I mean, I don't know, and then she can report back. I don't know if that's possible. No, it has to be.
I believe the request is to have a member of the zoning board. I don't think they differentiate between a full member and alternate member, but it's a member of the zoning board.
So you're voluntold, and we'll be hopeful that you're going to get reappointed.
Perfect, thank you. Karen, you will receive an email from the consultant at some point, probably this week. Yes, their name is Kelly. I am blanking on her last name. Kelly King, and it is from, they are from Horsley and Witten. So, and I will also be CC'd on that email, so if you have any questions, you can always reach out.
All right, do we have a motion to close this hearing?
Make a motion to close the hearing?
Second. All in favor? The meeting, or a meeting, yeah, I'm sorry, the meeting.
Make a
You
motion
got it.
to adjourn?
To adjourn.
What am I doing?
All in favor?